is when you get a letter in the mail, you got to go to court. So if you're going to go to court, you got to file these paperwork. So you're not going to file every affidavit that I prepare for you. Okay, you're going to file an objection for special appearance. Okay, why special appearance? Because you're appearing under the fear of you're under duress. So you're telling them, I'm appearing, you're going to have to prove jurisdiction to me. Now, sadly, most of these courts, they claim that they have jurisdiction because they believe it, and they won't answer that question. But you still got to file it anyway. Okay? Let me see here. All right? So basically, the affidavits you should be filing before going to court is a special appearance, a non-assumpsit, a demand for dismissal, failure to state a claim, demand to know the nature and cause for hearings. You're going to demand a change of venue to a court of record, and you're going to demand a trial by jury in a court of record. Now, right, let's say you already have a support order, right, and you don't have any court appearance coming up. So really, this doesn't work for you, right? Okay, well, is your support order signed by a judge? Probably not. Most of them are signed by these phony judges. But if it is signed by a judge, what do? Well, were you given a trial by jury? No? Okay, then the support order is void for violating your due process. Okay? And there's a couple of ways you can fight that void support order, right? I'll show you a real quick way. Okay? Stand by. Stand by. There we go. Affidavits for writ of habeas corpus. Right? And here's the instructions for writ of habeas corpus. Then I can show you what one looks like. Right? Look at that. This is just, by the way, look at all that right there. That's just my writ of habeas corpus folder. That's just one of 14 folders you receive from me. You're getting I am putting you in a position to win. Anybody that gets my paperwork and complains, okay, you can't complain against me because I provided you with weapons like more than anybody out there. Okay? Quite frankly, I'm probably ripping my own self off, but again, I am trying to help people. Okay, it's hard to help somebody when I'm asking for over $500 for paperwork. Okay, but also when I'm providing you paperwork, I am saying to you though, hey guys, you're going to have to fill in the paperwork. You're going to have to file because you're going to have to anyway. I can't do it. I live in New York. I'm not going to travel somewhere and file the paperwork for you. I mean, come on. All right. So, right. So I just told you that it's a void judgment, right? A support order is void. All right. And all you got to do now, if you have my paperwork, just take the time and open these things and read them. These are for the people that have my paperwork and you're still a Rick. What do I do next? Read the instructions. It's not hard. And go watch my videos. I tell you what to do. And I'm telling you now. Right? The petitioner is a victim of deprivation of property and denial of due process caused by a void judgment. Okay? A writ of habeas corpus is not just for people who are imprisoned, who are behind a cage. Any deprivation of rights is considered a restraint of liberty. Okay? So look at all these case laws here. Right? It is an adjudicated fact and evidence before this court that deprivation of property under the 5th and 14th Amendment requires due process of law, that is, a judgment by peers arising from a trial by jury. How many of you had a trial by jury? I sound like a broken record, but guys, that's the fact, Jack, as Bill Murray said in Stripes. Okay? But by a judgment of peers or the law of the land. Murray's Lessee versus Hoboken Land and Improvement Company, 1856. Okay? Injury caused, facts and evidence of an injury in fact caused by a judgment made in violation. Remember, we've always said that there has to be an injury in fact. You're the petitioner here now. When you file a writ of habeas corpus, you are the petitioner. And the fake judgment, the void judgment, is causing you pain, causing you mental anguish. Am I lying? Anybody that's made it this far in this video, if you haven't stopped listening to me, like most people do, if you're still with me, how many of you are dealing with mental anguish? I dealt with it. I was tortured. These things tortured me. Tortured. And that's why I do the videos. Okay, I did these videos for well over 6 months before I asked for a penny. Okay, and for a whole month I provided the beginnings of my paperwork for free back in December of 2016. Okay, I got over 10,000 hits. People like free. All right, I like free too. All right, okay. All right. So look, right here is just one affidavit to fight a void judgment, guys. You could get this if you get the paperwork from me. You could do this right away. You're gonna file it in an appellate court or an appeals court. Now, again, I am not telling you by any means it's gonna be easy. All right, you can talk to my man K1 about that. Okay, New York here, they don't like the slaves knowing that a writ of habeas corpus is to get out of jail or get out of fake judgment paperwork. Okay, is the way to go. But they don't want us to know that. So right here, and I just had my man John. I'm not sure where John is from. John went today to file a writ of habeas corpus, and you know what they told him to file? They told him to file an appeal. That's standard what they do. They told my man K1 to file an order to show cause. A writ of habeas corpus is an order to show cause. It's just, that's their version. They call it, and of course, conveniently, when they take a writ of habeas corpus and they rename it and they call it a writ of habeas corpus, because it's basically the same thing, you're asking for cause. Well, why are you doing this to me? What gave you the authority to cause what you caused happen to me? That's a writ, order to show cause. So basically, writ habeas corpus, what we're saying is, you restrain my liberty. All right, and you ask them to look at the facts, and then they have to issue an order undoing the restraint. It's basically the same thing as an order to show cause, except in order to show cause, a judge can refuse to sign it. There you go. And an appeal is basically the same thing. But guess what? On an appeal, a judge can dismiss it at any time. They have the discretion. The court has the discretion. But the court does not have discretion on a right secured by the Constitution. Okay, so they don't want us to know that. All right, so look. Today I told John, I go, John, you know, I gave you this. So this is telling the, all right, this is a New York case that you could cite. Anybody can cite this now. I'm going to give it to you. Or for if you're going to file a writ habeas corpus and they're going to tell you that you cannot, you have to file an appeal, you could cite this case. It's called People versus Schildhaus. It's the New York Court of Appeals. It's the highest court in New York. Although the challenge to the jurisdiction of the magistrate's court could have been raised by the defendant on appeal. Could have, right? From a judgment of conviction, he could have, but he didn't want to. And although that might have been more orderly and regular method, right? That's what they want you to do. They want you to do a more orderly and regular method because it benefits them, all right, of procedure. The right to invoke habeas corpus, the historic writ of liberty, the greatest of all writs, is so primary and fundamental that it must take precedence over considerations of procedural orderliness. This takes precedence over appeal, okay, because that might be the more orderly and regular method, but it's so primary and fundamental, right? The historic writ of liberty, the greatest of all writ, and right, also it's under Article 1, Section 9, okay, so that's right there. They're telling you you have the right to file a writ of habeas corpus before an appeal, before an order to show cause. I just gave you the case. You got it. Okay? And these are the other Tweed versus Liscombe, Sabatino versus Jennings. All right? But it's People versus Schildhaus. All right? Also, what else we got to do? Right? Because, you can't file federal rules law doesn't count in state court. So we got to let them know that under Howlett versus Rose, that the Supremacy Clause makes those laws the supreme law of the land. Because all federal laws are based on the Constitution, okay? They're enforceable in state courts. These are all things we got to notice these people on. What do you want? Let's fluff the cat. He's a pain in the butt. All right? So, I prepare you. I give you all the things, guys. You have everything that you need when you get my paperwork. It's just, guys, I'm sorry, but you're going to have to, put the work in, right? Special appearance. So, I'm going to give you the slides here. I'm going to shut this video down, what it's there for. So, just freeze it, right? And watch and look at it. That's what a non-assumpsit is. Because again, they're going to claim that you could be in default. You cannot be in default without an agreement. Okay? So that's what a non-assumpsit is for. You're automatically going to file a dismissal. It's like breathing. You're going to change the venue to a court of record. All of your rights are secured under common law. Okay? Under common law. And common law is practiced in a court of record, but they're doing they hide these places. They don't want us to notice. Okay? They don't want us to notice. So, these are the case laws. Trial by jury. You're going to demand a trial by jury. Why? Because it's your right. Every state constitution has one. It's funny how they all have it, but they all hide it from you. And they claim that they violate the 14th Amendment and say this law and that law says we don't have to provide you a trial by jury. Bullshit. Okay? Hold on, guys. Because my freaking mug is in the way here. Okay? Nature and cause. We're always going to demand the nature and cause. We want to know why they're doing what they're doing. Okay? An affidavit of service. Every motion, so when you're the respondent, Everything that you're filing is called a motion. Okay, and it's not getting, I don't want to get into arguments with all these common law people out there. Listen to me, or you could call it a notice to the court. You're going to file a motion because they're not going to accept it. I'm just telling you. You want them to accept your paperwork. You know, I got all these gurus out there like, oh, you can't file a motion, blah, 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 blah. Trust me, Rick tried all of these things, and I didn't get my paperwork accepted to fight these people till I had to play. You got to play a little ball with them. You got to get your paperwork in there. All right. So you got to, you know, then you put you word the way you want to word it once you get the paperwork in there. Okay. So that means anytime you file a motion, you have to serve the other party. So you got to get somebody over 18, right? You're going to mail the documents by regular mail. Now, if you're the petitioner and you got to serve a summons, then you get a service, okay, a service processor, okay, and then you got to attach it to your paperwork. All right, that's the real crux of what you're gonna file. All right, and if you have my paperwork, you have these slides, guys. This, you know, this is a little more in depth. Okay, a little more in depth. Basically the same stuff I provided you before. All right, guys, I'm going to shut this video down. All right, again, a lot of this was geared towards the people that have my paperwork. And hey, if you think about getting my paperwork, I'm telling you, you're not going to get any better than my paperwork. I'm just telling you that you got to put a little more work into it. You know, it's going to take a little bit of work. It's just the way that life is, guys. I worked my ass off to get off this shit. All right, but I know my stuff. All right. All right, guys, I'm going to shut the video down. Enjoy the rest of your night. Bye-bye now.